Hey guys, this is Roxann Smithers with Smithers and Ume-Nwagbo, and this is a note from my Legalpad. Today we have a three-part series where we're going to discuss business divorces. Now, a business divorce is a situation where a partner in an entity or a member of a limited liability company wants to leave that company. And there are three types that we're going to discuss in this three-part series. In part one, we're going to talk about a withdrawal or a buyout of that partner's interest. In part two, we're going to talk about substituting a new partner or member in the place of the partner or member who's leaving the business. And in part three, we're going to talk about that very unfortunate situation where the partners or members of the LLC decide that they want to wind down the business altogether and they're going to part ways and the business entity is no longer going to exist. There are some definite considerations that go into all three of these scenarios, and we're going to talk a little bit about those in the next three parts of the series. Hey guys, so this is part one in our series discussing business divorces. And in this part of the series, we're talking about a withdrawal or a buyout of one or more members of a business. More often than not, it's going to be either a partnership or a limited liability corporation in which these scenarios happen. The withdrawal or buyout can be either voluntary or involuntary. And the key to how that process works is going to be detailed in the operating agreement for that entity. And if in the unfortunate situation where the entity does not have an operating agreement, that is going to be detailed in your state's Limited Liability Company Act. Most states have a statute that sort of sets up the default procedures or positions for a company, whether it's a partnership or a limited liability company, and how it should run if the parties don't enter into a partnership agreement or an operating agreement. Now, one of the first things that you'll have to decide or will happen if there is a withdrawal or a buyout is whether or not that withdrawal or buyout can happen simply by a vote of the members of the entity or the partners in that partnership. And oftentimes it can either be a majority rule or you have to have a supermajority to either allow an individual to leave or to vote an individual out of the business. In some operating agreements or partnership agreements, there has to be cause found, meaning the parties have to decide that the party that's leaving the business has done something wrong in some way, shape, or form, breached the terms of the partnership agreement or the operating agreement, not performed up to a certain standard, had some level of conflict with the other parties or business conflict, or has simply not supported the business in a way that everyone has agreed that the parties need to support the business. So once you determine whether your operating agreement or your partnership agreement require a majority vote or require cause for a member to leave that business, either voluntarily, involuntarily, the next steps are deciding the process for that and what it's going to cost either side to do so. So in either situation, whether it's a voluntary withdrawal or it is an involuntary withdrawal, you'll have to determine the amount that person's interest in the business is worth. Because with the forced buyout, the company is taking the action of deciding that it is going to pay the individual for their interest in the business and they're no longer going to be involved in the business. Or the member that's withdrawing is forcing a buyout once out of the business and is forcing the business to come up with the funds to buy out their interest. In some situations, if a business has been having a lot of financial difficulties or it's a fairly new business, you may have a situation where in fact the entity or the individual who's withdrawing from the business actually has to reimburse the business. And that's a situation where there's negative equity in the business. Maybe as a new business or a business that's been struggling, actually their capital accounts are in the negative, which means that the individual has to pay their way out of the business versus the business needing to buy their interest, because now their equity is worth a negative amount. So that buyout can be facilitated, and the amount of that reimbursement or a buyout can be either detailed in that operating agreement or that partnership agreement, again, or the parties will have to negotiate a way in which they're going to agree to that amount. Sometimes it's based upon a set dollar amount that is established for each individual's shares, and then you just sort of do the math on that. Sometimes the equation is going to be based on determining the profitability of the business, looking at the assets versus the liabilities. Sometimes it'll be based upon the sales and revenue that's come in on the business. The parties can agree in advance on a formula to decide what's the value of the business. Or they can look to an outside source to provide a valuation for the business. There are plenty of businesses that can perform valuations. If the entity has been working with a qualified CPA, that CPA can give them a version of a valuation just based upon the raw accounting and numbers for the business and the tax returns showing the value of the business as well. But that's something that will have to be agreed upon between the parties. The next is figuring out the funding for that. Generally speaking, if the company has to buy out the individual's interest, those funds will be coming from the company, and that interest will go back into the business. And then the remaining members can decide how to divvy that interest up. They can do it proportionate to everyone's existing interest in the business, or they can divide that interest in a different way, thus creating a new sort of relationship between everyone in terms of their relative ownership of the business going forward. Another option for businesses who have planned in advance, who may have a buy-sell agreement or buy-sell insurance that can fund the exit of a member, whether that member is exiting voluntarily or involuntarily. Sometimes buy-sell insurance has limits on when it can be used, and sometimes it can only be used if the withdrawing member is incapacitated or is deceased and you're paying out their estate. It will just depend on the terms of that policy. Final piece that you'll have to have is your disassociation agreement. Some of the things that you'll talk about in that agreement as the withdrawing person leaves are how to handle liabilities of the business and of being a member of that business that existed both before they withdrew and after they withdrew. If there are any assets that have actually been established in the name of that withdrawing entity, you'll have to make sure to either transfer those assets to the business, which could affect that buyout price, or set up some sort of licensing or other agreement that allows the business to continue to use those assets. You'll have to agree on a payment schedule, whether it's a lump sum payment or there are going to be payments over time by the business out of revenue, out of profits, however the parties decide on that. And then also finally, you'll have to decide on that withdrawing member's access and use of any company property, any company assets, when their email will be set off, if they are getting reimbursements that have been coming from the business, expenses and benefits that have been paid by the business, how those things will be phased out as the individual leaves the business. And then making sure that that person gets any final documentation that they'll need from the business, like their final K-1 or copy of the business tax return or their W-2, depending on how they're set up within the business. So those are some of the things that you'll have to think about if an individual is leaving the business either voluntarily or involuntarily. For more information from the attorneys at Smithers and Ume-Nwagbo, you can reach us at stulawgroup.com. You can reach us on Facebook as well as LinkedIn. And this has been a note from my Legalpad.